right, welcome to a 40B edition of the Zoning Board of Appeals for July 14th, 2026. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Welcome, everybody. So, plan for tonight. Well, let's first start off with acceptance of the minutes from June 9th, 2026. Any input on those minutes? Any comments?
I move to accept the minutes.
Do we have a second?
I'll second.
All right, all in favor?
Aye.
And I am an aye. The minutes are accepted. Okay, so the plan for today, we are sort of hitting the home stretch here. We're going to talk through the decision document, the waiver document. They have been refined. There are perhaps a couple small textual edits that will need to get made, but the content is there pending our discussion. And so we will go through these items, what they mean, what we will be voting on, what has changed since the last time. Most of them are fairly small changes from the place that we ended our discussion at the last meeting. And then I'm going to open up the room to public comment so that we can get input. And we also have a public comment that was just submitted today that I also want to reference. And then we will discuss, and we will see where we are as a board, see if we are ready to begin the voting process, and if we are up for closing the public meeting, and then to deliberate and vote if we are ready to do so. All right, with that, I think the way that I'm going to do this is Mr. Smolak and Mr. Steinberg, you guys are welcome to come up and join us. I think I'm going to have Ms. Murray drive, with your permission, and walk us through these elements. But I would love, if you have input or disagreement with the interpretation of what is being said, that will be helpful to just make sure that we're all getting on the same page here. All right, Ms. Murray, should we begin with the decision document or the waivers? What's the best way to go?
Whatever. Might be better to start with the waivers.
All right, then let's begin with the waivers.
Melissa's online, right?
I believe she has not logged on yet.
We went through the waivers pretty well last
We
week
did,
when
yes.
She missed
didn't seem
one.
like there was too much for changes, but we didn't really spend much time on the decision,
So
so I
she
just
in theory could still
was hoping we could spend.
vote if we don't.
And I think all we need to do with the waivers, just highlight the changes. Because I agree with you, unless anyone has a new question on any of the ones that are unchanged, no issues. So you should have two documents for the waivers. One is the red line version, one is just the clean version that accepts all of those red line versions. I'm going to work off of the red line version just because visually it is easier to identify what the changes are, because as Mr. Kilaleo was just saying, we did spend quite a bit of time at your last meeting going through the waivers, so in the interest of time, we'll just focus on where the changes are. But anyone can certainly stop me as we go along.
That's the one that you handed out, Terry?
That was, so the one that was handed out today to you, that was also sent to you earlier, is the clean one. The one that was previously given to you is the red line version.
The one you picked up.
It has red
Yeah.
lines on
That's
the very
red?
first page.
The one that has red on it, yes.
Mine actually shows up as blue, don't ask me
Okay.
why.
Well, this one has the same
Are you
text
sure
on it.
you're not just colorblind? Is that? I'm just kidding.
No, I printed out blue, I don't know. So just, I'll just stop at each one where there are any real substantive changes. Beginning on page 2, this has to do with the sewer licenses and the house drain connection. The language was just added to be clear that the applicant is not asking for and we are not granting any waiver of the sewer service connection fee or sewer mitigation fee. Turning to page 3, that was really just a typographical change, nothing of substance there.
On the line of typographical changes,
Sure.
on page 5, in underground utilities, it says waived granted, is that waiver
We'll say
granted?
waiver, thank you.
I'm not sure it would matter, but it just confused me.
No, thank you. Page 7 has to do with parking, and really, again, just some, not really substantive changes, but just making it clear as to, we added in the structured parking garage and surface parking as an accessory use, consistent with site development plans as opposed to final plans. The final plans will obviously come later in the process when the subsidizing agency has reviewed the plans, approved them, and then building permits are applied for. Page 9, pertaining to signs and lighting, the changes there really are just to memorialize what was discussed at the last meeting in terms of the existing monument sign that's going to remain, and we reference that, one additional ground-mounted sign, and then we do refer to the signs over the entrances to both of the buildings, as well as the entrance to the garage, making it clear that the language is subject to, it's just a placeholder. It will not say entrance and et cetera. It'll probably say something else entirely.
I had that as page 8.
Page 8.
Mine.
Mine is showing up as page 9, so I'll
Oh,
go by
okay.
the
No, you-
number of the waiver instead. How's that, okay?
Oh, no, if it's only off by a page,
That's,
page number's easier, I think.
so waiver number 9, again, is really just clarifying what sheet we should reference relative to the dimensional requirements. And we will also have to make sure that that the conditions, it says at the very end, it says is subject to condition 5.3 of the comprehensive permit. We'll go through for one final reading on our end to make sure all of the numbers referenced in the waivers also line up with the decision, because sometimes when we're editing and accepting changes, section 5, number 3 may become section 5, number 4. So we'll take care of making those consistencies. On waiver number 10, this is really the heart of it. This is where we start with the dimensional requirements. And this is one where it may actually be easier to look at the clean version as opposed to the red line version. The applicant has kept in the various zoning districts just to show for illustration purposes, but we have eliminated some of the language where if the development complies with those zoning requirements for those various zoning districts, we've removed that from the waivers because it's not a waiver, and tried to just limit this to simply highlighting what is the nature of the waiver itself. So, for example, in beginning with sub-district A, we've narrowed it down to the minimum setback, which,
So, I
I'm
want
sorry.
to comment just,
Yeah,
it
we don't have-
appears that
The
in the
formatting is-
non-redline version, it broke the formatting.
Yeah.
Yeah.
And so,
So look at the
we are
red,
not.
look at the
You're
red
right.
line.
You're right, with
So-
required and waiver, you're right, okay.
Well, like, it looks like this, just for,
Yeah.
There is no number 10.
Yeah, a lot of
Um,
things just disappeared.
yeah. So, that may,
Interesting.
that may be.
Okay.
I have a hunch
Could be a
that
printing.
is a Word to Google Docs breakdown, that this might have been
Okay.
printed out through a Google Doc, and that's what caused
Okay.
it. So, all's which to say, the safest thing probably is that to provide a version of this in the end that is in a PDF, just so that.
It will be, yes,
Yeah, just so
yes.
that it is less likely to have that issue in the final document.
And
But,
for clarity now, let's just look at the red line version.
yeah, I think we can look at the red line version and it'll be fine.
All right then.
Because that one, the formatting is still okay for the
Okay.
most part, so.
So, with respect to what should be hopefully numbered as waiver number 10, the dimensional requirements beginning with sub-district A, we reference the minimum setback where what is required is a 35-foot front, side, and rear yard setback. The waiver would be to allow a setback of 17.5 feet off of Prescott Street. And then further down, the existing structure provides a front setback of 34.4 feet from Prescott Street, which would be the other wing of the building, as I understand. Turning to the next page, the waiver that stays in is the maximum height, which would be 55 feet by special permit in Subdistrict A. It will read that the maximum height will be no greater than 55 feet.
If I could just mention one thing.
Sure.
Yes, please.
Just going back to that first Sub-District A waiver. In terms of language, it's a 17.5-foot setback, and I think underneath that, the point was to identify where the existing structure setback is of 34.4 feet. So I just wanted to clarify that.
So it reads, waiver granted to allow for a setback of 17.5 feet off Prescott Street where 35 is required. The existing structure provides a front setback of 34.4 feet from Prescott. Is that what that's the entirety of the text, right?
Yes.
Would it be helpful to at least give you one copy of the clean that has the waivers, so
That's not,
that's
Well,
not cut
it's
off?
funny
Would
formatted.
that be
I
helpful?
mean, I think having me just look at it alone is not terribly helpful, but that's okay. We'll be all right. I can read through this and figure it out, I think.
I mean, yeah, that was,
What's wrong with it, John?
What's wrong with?
With the way the waiver?
Oh, no, I think it's correctly worded.
He just wants to
Oh,
help with
oh.
readability,
Oh,
Yeah.
I got you.
But I
which
think
is
he
an
was-
understandable thing.
I think he was clarifying that, like, we were, just talking about the 34.4 as if it were in the other part of the zoning overlay, but it's
it's
actually
not.
just what the existing setback is.
Yeah,
Yeah.
okay, that's
Right.
how I took it, but, okay.
Then I think we can move on to waiver 11. And this would now be in the IS district. What should remain is the front setback where 30 feet is required. And the waiver would be granted to allow 19.9 feet from Prescott Street.
I'm either
don't
missing
have-
a page,
yep, I know I
or
don't
we
have
skipped
11.
right to 12 in this version.
Right,
So, no, it's.
but 11's in the clean one.
Right, but I'm just in the one that we're looking at, so like
Yeah, I don't have it either.
in the red line version, I think it maybe is
I think it-
12, which is Article 7 dimensional
The clean version
requirements.
was not helpful, apparently, in the end. I'll stick with red line.
Well, no. So here's the problem: is that the red line version now in this case is the one that's broken, and the clean version actually
Right,
has
because
it.
it just skipped an 11. It went 10 to 12.
I'm so curious that it does that in certain versions and not
All right,
others, but
but
okay.
what we have, we between the two of them, we have it. So, all right. So number 11, we have.
So what I'm seeing is 12 says dimensional compliance is shown on sheet 4 site plan of the site
No, we're
development
talking about
plans.
11 now. So in the clean one.
Yeah.
Oh,
the clean
just
one.
skip entirely over to the clean one?
Yes.
Okay.
This is
I
unfortunately
just wasn't sure if it
chaotic.
was just a numbering issue.
No.
There is completely.
It was referencing like the same things, it looked like it was.
Yeah, it looks like it's referencing the same
But
thing.
it's not though.
All right.
It
but-
is the same, but that's okay.
Because 11 and 12, I believe, are the two different zoning sections, right? Like the two different, one's for, no, okay.
Yeah.
They're both,
Yes.
Yes.
You should
Yes,
have
one is
subdistrict.
for industrial, one is for R4. Right, so 11 is the industrial waiver, and 12 is the R4 waiver, right? So,
okay. I see
right?
that, yes.
So that's why they look the same, because it's referencing the same part of law.
And the same verbiage until
Right.
it gets to the specifics.
Yeah.
Gotcha.
Yep, okay.
Okay, so 11.
All right, let's continue with 11.
Okay, so we're still on the IS zoning district.
Yep.
In addition to the front yard setback waiver, they're requesting a waiver from the floor area ratio.
Yep.
such that the waiver would allow a ratio of 1.57 to 1,
Yep.
where 0.5 to 1 is required. And then moving on to what should be the R4 next. So again, we have a minimum front yard setback. "30 feet is what is required. The waiver is to allow, again, 17.5 feet from Prescott Street. And then maximum height in the R4 is limited to 35 feet. And they're requesting a waiver to allow up to 55 feet high. The next one then, the required yard setbacks, which hopefully is waiver number 13 on yours.
Yep.
Yes.
So this is where it's really just cleaning up the language to make it clear that the yards comply with the zoning bylaws except as waived above in the various zoning districts and is depicted on the site development plans. Building height is the next one. Again, you've granted a waiver from building height as we've just gone through, but we've added in that the maximum building height shall not exceed 55 feet. The next waiver is maximum lot coverage. The project complies with the maximum lot coverage requirements of the zoning bylaw except as waived up above in the waivers we've just discussed, but we've also added in that maximum lot coverage shall not exceed 34%. And then the final one dimensionally is for floor area ratio. You've just granted a waiver up above within the zoning districts from floor area ratio, but we've added in that maximum floor area ratio shall not exceed the 1.57 to 1 ratio. So hopefully that helps the building inspector at the time of building permits. Then we move on to hopefully what is number 17 or Article 18, the supplementary regulations relative to parking requirements. This is consistent with your discussion last week, where we've made it clear that the waiver allows for a total of 467 non-exclusive shared parking spaces, and it enumerates how many are on-site garage spaces and on-site surface spaces, with the breakdown according to the bylaw based on the number of dwelling units to show that 467 would be what is required. The next one, the location and layout of parking spaces. The waivers granted to allow for the parking location layout as depicted on sheet 4 of the site plans, of the site development plans. And again, we'll cross-reference the proper condition in the comprehensive permit as well. The next provision is special permits for parking.
This is number 19.
This is number 19,
Those
hopefully,
following at
yes, okay. As you remember, at our last meeting, we had some discussion as to whether or not, in my opinion, it was necessary to get a waiver from the special permit provisions. But at the same time, the applicant is requesting that the board modify a 1984 special permit. So the applicant requested that this stay in. So this waiver, the language just modified to say that to the extent that it is required, the waiver is granted to allow for parking, again, as shown on sheet 4 of the site development plans. The next substantive change comes in under what should be waiver. Sorry?
Actually, just really quick to clarify.
Yep.
If we grant this, there's nothing in waiving that special permit that would allow them to like just build a 5-story parking building instead of doing any of this project? Like, this, it has to be tied to this comprehensive permit, right?
Correct.
Okay.
It's only in the context of this. Like, they can't suddenly shop this around and turn this into a commercial redevelopment, for example.
Yeah, not that they would need 5 stories of parking without additional residential, but just to clarify.
Right. Let's see, the next substantive change.
Number 20, just another waived versus waiver. We should just
Okay.
iron that out, but.
Okay. 21, simply, the only real change is just to reference the screening and landscaping plan that was included with the site development plans. Then the next substantive change is what would be waiver 25. It's the special permit provision under section 195-10-7. And this is what I was alluding to earlier, that they're requesting a waiver from all of the special permit procedures, primarily for the purpose of being able to modify that 1984 special permit. Then the next substantive change would be number 27, the zoning overlay district. Again, multifamily would be allowed by special permit, but to the extent that any waiver is required, it is granted because we're granting this 40B, which would exceed the multifamily requirement by special permit. The next one, my numbers are cut off here, but it has to do with the plans. I think it is number 29. We just clarified based on discussion with the board last time as to the size of the plans and to be submitted once final. And that's really it in terms of any substantive changes to the waivers.
If I may add one item, there was, in the red line, there was one waiver that we struck, which was lot slope requirements, and we're just withdrawing that one because we made a determination it wasn't applicable.
Sorry, which one is this?
It's lot slope, it's,
Was
Oh.
22.
I don't know
Oh,
if it's in
okay.
your red line, if it shows.
Gotcha.
Yeah.
So would you like to move on to the decision at this point, Mr. Chair, or pause here
I
for a
want
moment?
to check with the board. Any additional thoughts or questions before we move on? I feel like this is sort of more or less what we came to last meeting.
Yeah, I think it's mostly clerical stuff, but.
Yeah, and I appreciate Ms. Murray and Mr. Smolak, you guys going through and where possible, putting numbers and things in place. I understand that that was a little bit challenging given the particular nature of the split zoning in this this area, but I appreciate it because it'll make it just simpler down the road for us when approving it and when the building inspector needs to improve it and things like that. So thank you. Okay, all right, let's talk the decision document.
So again, do you want to go through section by section? Do you want me to just
And if you had
focus
some
on the
highlighted areas, right?
highlights?
I think major changes and highlights, yes.
Okay,
Because I like with the waivers last meeting, we went through them step by step. And so I think we don't need to do that again.
okay. So I think the first significant change appears on hopefully page 6. It is the last paragraph right above section 3, findings of fact.
Yep.
The prior version, we were listing any specific.
Terry, your screen is up on the. I understand, but it is public to the whole room.
So at the last meeting, or the last draft that the board had seen, there was more of a list of public comment that was received with a question as to what is the board's practice. And the consensus of the board was really just to reference all of these, sort of condense them into one paragraph of issues that were raised, and note that they're available on the board's website. You know, if there is a specific link, we could even insert that here if that is known, or whether it will change in the future.
Yeah, Ms. McNeil, would it be possible to have a link that is at least somewhat permanent that we can provide Ms. Murray for the public comments on the 40B?
But I've been able to access them through the links now because I figure they're all still live. But say a year from now, will that link still be? Okay. All right, so get that address.
I think when you pull up the agendas, like the last agenda, I think Terry had put in there all the other prior agendas which have links to all the documents.
Yes.
Yeah.
So I think part of it is that all those are saved on Google Drive, and those kind of make for unintelligible links, and that if somebody's manually typing them in, they're kind of miserable. What we have on the North Andover town webpage is we have a 40B section, and in there we have all the documents that have been submitted. And so if we can place a link to that, and if that is going to persist long enough, I think is Ms. Murray's question, then that's probably the better way to do it. And so I think if we can keep it to that site, that's probably the best way to make it happen.
Would it be easier to just say on file with the board at town hall?
Do that too.
That never changes.
Yeah, well, I think maybe say both. The reason is that will, of course, be a public record that we maintain.
Right.
I want to make it as accessible as possible.
Understood.
And not make people call into the board, into the town, and figure out how to get access
And
to
hunt
it.
around.
Right.
Understood.
But, yeah, no, I appreciate that, yeah. That would certainly cover us in perpetuity.
Fine, fine.
Yeah.
I'm in favor of both.
Okay, can do that. The next substantive change, I'm going to skip over paragraph 28 and 29 for right now, because that really goes to the heart of when the board's ready to vote. So skip those for now. One change, the next substantive change appears on page 16 in paragraph 6, and again, it's highlighted. Just to make it clear that pursuant to the regulations, you know, we've got, the applicant has 3 years from the date the decision's filed with the town clerk to actually exercise the permit. Applicant can certainly come in and request an extension of that time. And to clarify that, requesting an extension of the decision does not constitute a substantial modification under the regulations, which would require a public hearing. Instead, it's something the board could just vote at any planning board, at any zoning board meeting. The next substantive change appears on page 20.
The page 17, just the at the planning director's request, that was something that we had discussed in the last meeting. I just
Yes.
wanted to
Yes.
say that is in there, and that's the way that it's written, so.
So on page 20, paragraph 27, there was a lot of discussion at your last meeting about potential contamination and testing. Sorry, my phone's deciding to talk to me. Testing of the site, et cetera. So I think this is probably some compromise language that we agreed upon to include that the applicant, prior to the issuance of any building permits, may conduct soil testing for potential health or environmental contaminants that would have to be done in accordance with industry standards. Anything that constitutes a release under state law would be required to be managed, abated, remediated, removed, whatever might be required under the applicable state regulations. with notice to the Department of Environmental Protection as necessary.
This is one of those places where my lack of lawyerly training is showing. When we say may conduct, what does may conduct mean? Does it mean just they have the option to or not as they see fit?
Yes.
Okay.
We talked a bit about, obviously there's going to be a due diligence period, and maybe Attorney Smolak can describe what the plan is, a little more detail. So we are not necessarily mandating that the testing of the soil be done, but if it is to be done, it's got to be done in accordance with state standards, and whatever they happen to detect would have to be possibly reported or dealt with in accordance with state regulations.
Got it.
And was it a non-starter to have that be a shall instead of a may? Or is that not within the purview of the comprehensive permit?
Well, we are sort of walking a line here, because the zoning board is only really dealing with local rules and regulations. We aren't here to also enforce any state requirements that might be applicable. Certainly, maybe the applicant wants to speak to what they may be required to do, but at least we're acknowledging that if there is some testing to be done, we understand it has to be done in accordance with state law.
Gotcha.
Did you already do a 21E?
Well, I guess what I'll say is that RCG wouldn't have acquired the property had they not done the proper environmental investigation when they bought it back in 2007. So I don't think there's anything there of concern. Could there be? Possibly, but unlikely. And the other fact is that when this gets financed, a lender's going to require an appropriate due diligence in terms of investigation. And as was mentioned also, it's a matter of state law, as Attorney Murray had indicated. And basically, the Housing Appeals Committee case law has suggested that matters of state law are dealt with. The board can require compliance with state laws, but they can't mandate anything beyond what the state law requires, arguably absent a local hazardous waste bylaw, which the town doesn't have in that circumstance. So it's not like we're hiding anything. It's just a matter of how the due diligence is going to be undertaken at some point. And if there's something to report, certainly we report it, and we'll follow all laws regarding that. That's all.
Right, but the state doesn't require you to do any soil testing.
No.
If you come across something, then you have the reporting requirements. But have you done, when you bought it, you must have done a 21E.
Yeah,
So it is,
We've got an environmental
were
report.
there any signs of releases or?
No, and they would have had it been resolved at that time with those reports. So I think
So it's probably
Attorney
gonna-
Smolak's saying, it's more of a question of whose mandate is it to test what,
Yeah.
when, and we'd like to have it, be a matter of the state law then.
Yeah, so it's probably gonna be more of an occurrence, since nothing showed up in the 21E, it's probably gonna be more of an occurrence if you actually discover something while excavating, and then you'll have to follow the guidelines.
Or if the financiers request more, they would do it too.
Yeah.
Just
If
saying.
the 21E is clean, they usually don't though.
Okay.
And they'll require an update
Yeah.
from what we've had in the past.
I should also point out before we leave page 20, that in condition number 25, we did add at the board's request to make it clear that the health department would be part of the pre-construction conference.
But the zoning board isn't listed. Us should,
It's actually listing town departments, not
Oh.
necessarily boards.
okay.
There's
Oh,
no reason.
yeah, I read planning department, so I was thinking planning board, but you're right, okay.
Yep.
Yep.
You have the right to show up anyway.
Yes, but not too many of you without posting meeting.
Yeah.
Attorney Murray took care of that. She doesn't miss anything.
Turning the page to page 21 and subparagraph C. This again was something that was discussed a bit at our last meeting. So we made it clear that the construction management plan will be submitted to the board as well as to the building commissioner for your review and approval prior to construction beginning. And that one of the elements it must include will be a dust mitigation plan.
On Part D of that, the SWIP is being submitted to the DPW and building commissioner. Wouldn't the conservation agent be someone who would,
We could certainly
'Cause they-
add that too.
they typically are the ones who would be monitoring that?
Okay. The next substantive change appears on page 25 at paragraph 44. Again, just to highlight, the existing garage will be demolished. No tree stumps or other demolition or construction debris shall be buried on the property, but has to be properly disposed of in accordance with applicable law. And no burning is allowed on the property. The next substantive change appears on page 30, and it's condition number 81, detailing a little bit more the stormwater management maintenance plan and the operation and maintenance plan that must be submitted for the stormwater infrastructure. This also, I think this was sort of an open question. We did discuss this at our last meeting, but I don't know that the board had reached a determination on it, because this included language that in the event that the applicant or their successor fails to maintain the stormwater system in accordance with the operation and maintenance plan, the town may perform that necessary maintenance or repairs, and if so, we could then seek to be reimbursed by the property owner or manager for that in charge of municipal fee. We discussed it, but like I said, I don't have in my notes that the board had reached any determination as whether you wanted that in or out. We're not required to do any of this maintenance if they fail to do so. Just some communities I've worked with where, you know, the stormwater management infrastructure that's on their site eventually or usually also connects with our system at some point, so failure to maintain on their site can sometimes have a domino effect. So there's sometimes interest on the part of the town to want to make sure that that infrastructure is maintained.
Yeah, and I think given the particular history of this area and just the experience with flooding that we've had, I think that this is something I would like to keep in there. So.
Okay.
I've also seen a lot of smaller subdivisions, but subdivisions that have drainage that was not maintained, and now it's a, big problem. It does look like it's already written in that costs could be levied in a municipal charge or fee.
Exactly,
Okay, all right.
yes, yep. The next substantive change,
So number 85.
85 was removed, and I'm trying to unfortunately read through this very dark highlighting. I think it was removed because it was duplicative
Yes.
with the other paragraph about the operation maintenance plan, or it was overlapping, so we deleted that.
Yeah, it says a necessary condition, given that the stormwater improvements would be monitored under a long-term O&M plan.
Yes,
That hurts my eyes.
yes. It's a little hard to read.
Yours blue text and your
It
blue
is
highlight?
blue text
Yeah,
and blue
okay,
highlights, so
yeah.
it's,
Oh,
yes.
yeah. Yep, the red with the blue highlight is still tough.
And I think you added language in 82 and 83 to close any gaps too.
Yes, yeah, we kind of conflated the two. So then paragraph 89 is, again, just talking about consistent with the board's determination at the last meeting about the shared parking situation. And we added this language that's highlighted at the end of paragraph 89 that says, to the extent applicable, such existing planning board special permits shall be deemed modified to allow for shared parking as approved by this comprehensive permit. And if in the future, as a result of changes of uses within the mill complex besides this 40B, those new uses are subject to a requirement for additional parking. Under the zoning bylaw, those parking requirements are to be addressed by the planning board. So in other words, we acknowledge shared parking, but we're really only concerning ourselves with parking as it pertains to service the 40B. All the other mill complex users,
Are on their own.
if they require a special permit or they have to go to the planning board now, that's exactly where they're going to go if, there's a change of use or a new use that comes in. And then in paragraph 90, this is acknowledging that 1984 special permit decision that limited the garage height to 2 levels and makes it clear that we are, to the extent necessary, we are hereby modifying that special permit to allow the garage as shown on the plans to support this particular decision.
And this was another piece that you felt was unnecessary, if I recall.
I did, because the 40B regulations are clear that an applicant only needs to seek a waiver from as-of-right provisions of the zoning bylaws. So we don't need to grant waivers, and they don't need to seek a waiver from any special permit requirements. And in my mind, they don't necessarily follows if you don't need to a waiver from a special permit requirement, you shouldn't also need to need any sort of modification of existing special permits. But I recognize this is part of a larger complex with some, as we've said, we've spent a lot of time talking about the shared parking and how it all works. So I don't see any harm in it
Okay.
being included here.
The other reason that we wanted this included as well is when you run the title, you'll see this old 1984 ZBA decision. And then, but if you read the comprehensive permit, you'll see that this modifies that. So it's a way to sort of clarify that in the chain of title as well.
For folks who may not be as familiar with 40B and know that that overrides special permit stuff.
So then turning to page 33, the next substantive change appears in paragraph 102. So 102 and paragraphs 102 and 103 sort of go together. Paragraph 102 was what I'll call the pedestrian monitoring plan that VHB had recommended occur at certain milestones once the project is occupied. And then paragraph 103 is the traffic monitoring and parking demand that would be looked at upon 70% occupancy. The change was made to make sure that both of these studies occur at 70% occupancy. The last version you saw was
75?
Yeah, it says 75, but that's probably blue on blue for you. But it's in here, it's
I'm sorry, I
75.
meant to say 75 if I didn't say that. I'm just going to say, the last version for the pedestrian safety study, I think was going to be at milestones of 60% and 100% occupancy. From their perspective, if they're going to be out there doing these assessments and monitoring of the site to see how it's all working, might as well do it for both traffic, parking, and pedestrian safety all at once. So they'd like them both to be done at the 75% occupancy milestone.
And it's rare if ever you have 100% occupancy anyway.
Right.
Yeah.
Well-
But it could be higher than 75, I was thinking. I forget why we just talked about it being 75%.
I think that's because that's what VHB had recommended.
Yes, yeah, VHB had recommended that.
The other thing is that the difference between 60 and 75 may be a matter of weeks, right? Like we're not necessarily, it's not necessarily obvious what those milestones will actually be, but.
Right.
Okay.
Frank, would you prefer like an 80% occupancy or?
85, or, I don't know, it just seems like the higher the occupancy is at the time they do it, the more representative it will be of the permanent situation.
Sure, although I think we can make some scaling, right? Like
Extrapolate.
I don't think it'll be that far off.
Well, that's sort of what a lot of the residents they've complained about, the parking studies and that sort of thing, so I just, they say, has it been done recently, or this, that, the other thing, so
Just for informational for the town, right? I mean, they're not gonna do anything with
Well-
the results other than
No,
pass
there
them
are-
on to the town.
There are possible mitigation measures listed in here that they might be
It's
interested
more
in
like
doing.
making recommendations about, once they have the results, making recommendations, I think, right?
I mean, there are some things that they said that they would be willing to do, but then
Oh,
beyond that
discuss,
would
yeah.
be recommendations to the town. So I mean, I think it's really a question of like, what is this,
I don't think, well, you don't care when you do it, right? You just wanna do it once, so.
So, I mean,
75 or 85, it's.
yeah, I wouldn't make it above 90 just because then we might be waiting a while, like if there's, you know,
Right.
and so that's the risk you run with making it higher. But if you want to set it at 85, I'm not going to object.
Well, there's
So.
such a demand for housing, they should get 85%.
They should. They should. So,
I would have no objection to making it 85, if that would, feels like it makes more sense.
all right. Ms. Murray, are you okay with altering that? All right.
I guess I would just, through you, Mr. Chair, I would just ask, what is their typical occupancy rate?
Do we know what
Others
the
we know.
occupancy rate of the Avalon facility is at this moment?
I don't know their occupancy right now, but they're typically over 90%
Yeah.
occupied, as have we been in our.
I was going to say, my understanding is pretty much all of North Andover is over 95% at this point as a whole. So it would not surprise me that we hit 85 pretty quickly, but.
But in terms, so like, especially if we have the two wings of the building being phased in differently, and this is 85% occupancy for the entire project, right? This could be a difference of like several years, right?
Well,
Between,
they're not gonna,
well, not between
Not
75 and
several years.
85.
they're not gonna hit 75% just one phase either
Correct,
anyways, so.
yeah,
It may be the difference between 2.5 and 3 years.
from
right.
75 to 85%.
Yeah, because
So
what
is
you're,
that an acceptable timescale for waiting then?
No, well,
I'm just walking us through the entire
At
decision.
75%, they're not gonna, even if they finish one phase, they're not gonna reach 75%, which
Right.
is one phase done anyway, so.
Right. I
but
would-
it would be half occupancy of the second phase, right? Or, I mean,
Roughly, yeah.
I think we're splitting hairs here.
I mean, I
Right.
agree. Frank, what would
I
make you
think we're on
happy
this-
here?
I think 85 is good, I think
85, okay.
All right.
we're on the same page.
Turning to the next page, page 34, under architecture, landscaping, and screening. Condition number 104 was changed with respect to the tree preservation plan to add in that the execution of the plan shall be overseen by a certified arborist, and incorporating some of the provisions that were, the notes that were on that landscape plan that we got at the last meeting. Condition number 108 makes it clear that external lighting has to be dark sky compliant, and that the light spillover that we saw on the photometric plan is just site necessary lighting, not, not anything relative to landscape lighting, for example.
So this did prompt a question for me, sorry. The photometric plan that we saw was based on site lighting. Did it include any, like wall packs that are building mounted in that analysis? Or any other building associated lighting?
I would say on the plan, it carried the architecture, so if there were lights designated to be outside, I think it would have been carried on that plan. I don't recall, I think most of the site lighting was done on, not off the building in that respect, but I think the photometric plan would have included any lighting coming off the building as well. Yeah, okay.
Okay.
In paragraph 110, signage, that was just, again, similar to the waiver we looked at. The signage paragraph was updated to reflect the new information that we got at your last meeting. And that is it.
And I know this is very silly, but okay, yeah, such signage is considered placeholder signage with the final contents to be shown on the final plan.
Yes.
So that you're not stuck having garage and building and
entrance, yes.
Yes.
Although, kind of perky.
It would be a fun story to tell, and I would drive by showing my kids exactly what happened. You know, let that be a lesson. But, okay. Any additional questions on these waivers? Anything that we feel is not yet fully addressed?
Well, I have a few.
Please.
Number 11. I think I might have said these last time. But
Number 11 on which page, if
oh,
I may?
9.
On page 9, okay.
Says with respect to the building design and site layout, the board finds the applicant has been responsive to architectural peer review, board and public comments. I just don't know that, I guess the public feels that they've been responsive to their comments. Do we have to say?
So I want to reiterate that this is your decision, and it can say whatever you feel comfortable saying. Some of these paragraphs, like you see at 9 and 10, 11, it was language that the applicant requested be added into the decision. I don't typically include this kind of detail from peer review reports, but I do also understand that it's sometimes helpful for the board to make findings based on some of that feedback from the peer review reports.
I also do think there was a response. It was not as full
Yeah, but-
as would have been
And,
according to public comment.
and again,
but-
Well, I
this,
guess
we can modify this, you know.
I don't necessarily feel that it's been,
Responsive.
they might have responded, but not to the.
Yeah, so I think
Yes,
responsive implies, in my view, that they have responded in a way that has satisfied the complaints to our satisfaction. Not necessarily to the public's, but to our satisfaction.
Well, can't we just
And-
take
Is this
that
necessary?
last, take out and public comments? Why
Well,
do we have to
and so what I was
approve
gonna say is that if you do not feel that that is the case, then I think we can remove that language, and it does not affect, in my opinion, the substance of the decision.
that? Yeah, I don't
So-
think it affects anything, but I don't want to make it sound like we're speaking for the public, that it's been responsive.
I do think that they've been responsive to architectural peer review. The architectural peer review was very light.
Yeah.
In fact, if anything, they've done
I
far
think
more
what-
than the
I think
architectural.
what Frank is
peer review.
suggesting is that we change it to responsive to architectural peer review and board comments.
And just take out public comment.
Yeah.
I got
I think that is a reasonable statement. Because I think, because, you know, I think the public has been clear that they want something much more significantly altered than we have, than we and the applicant have negotiated thus far.
And then, let's see. It's kind of the same thing on page 14, number 27 and 28. About the
And we did want to
strong
circle back.
opposition voiced by several members of the public, and the board finds the applicant has adequately, I guess it's saying, yeah, I don't know.
So if
Does that have to be stated?
So if you remember, when we started reviewing the decision, I said, I'm going to skip 28 and 29 because those ultimately become like your ultimate conclusions. Do you feel that the applicant has adequately addressed these concerns, or do you want to change that in some other way?
Well, but let's talk about 27, right? Because 27 is before that. And I think what Frank is asking, and I think is a reasonable question, if I read these things, they feel like rhetoric, right? They feel like rhetoric more than they feel like substance. And I guess my question is, are they purely rhetoric? Or are they designed to deal with a future potential court case? And would this be cited as evidence in such court case?
I think they're both, to be honest with you. Certainly to address any potential appeal that comes, to be able to say, but look, the board did consider the density of the site or the height of the building, or whatever it may be. Is this necessary to your overall decision? No, it is not. Could it be deleted, or could it be modified in some way? Yes, it could be.
Like, I don't think it may have necessarily adequately addressed the public's concerns. It might adequately address what we need to vote on for a 40B project, but that's different than the public's concerns.
Well, I guess that's what is the adequately referring to? Like, adequately enough for us to
I know, but I guess I'm just saying,
acquiesce, or?
do we have to make the statement? If we don't have to make the statement, let's
Yeah.
not make the
You
statement.
truly don't, because what it basically says is the board has heard the public's concerns. It's still your decision, whether you feel that they've addressed all of the public's concerns, some of them or none of them. It doesn't change ultimately what will be your decision. So,
Right.
It's a different statement for the board to say the board's concerns have been addressed versus those of the public. I think it's a very different.
grab a microphone?
Oh, sorry.
No, it's no problem.
Sorry about that. I just think it's a different statement to say the board's concerns have been addressed versus those of the public.
Yeah, and I think I'm much more interested in the first category
I
than the
understand,
second
right.
as our text. And so I think if we can look at both 11 and 27 with that in mind and say that, you know, we are addressing our concerns, and some of our concerns have come through public comment. But, you know, I don't think the applicant in this case was directly engaged in negotiation with public commenters, and in fact, the structure specifically does not allow that.
so we could certainly change 28 to say that the board, should you make this finding, the board finds that the applicant has adequately addressed the board's concerns as described above. 27, in my opinion, still does not need to be in the
So I
decision.
think we leave 27 out.
Yeah.
I think we can remove 27 altogether. And then I guess the only question is back at 11, if,
Well, especially because
how we want to,
that's sort of redundant with the list of public concerns from the
Yes.
beginning, right? Yeah.
yeah. And in fact, 11, I might even just change the language to be just much more dry, which is to say that the applicant has responded to architectural peer review, board and public comments by. Right, rather than saying they have been responsive, we use the active voice, they have responded. Right, I think that is more accurate. Is that a reasonable?
Yep.
Okay.
I agree. Were there any other ones of those that anyone flagged?
The ones that caught my eye.
I mean, I think there's 26 also is a little bit of rhetoric, right? It's that it's consistent with smart growth principles, and further finds the location is consistent with principles and goals of North Andover Master Plan. I'm not sure that is really.
I wasn't.
I'm not really sure that is our purview in this case either, and so I might remove that one as well.
I mean, that's also the crux of 25.
It's, if I may, Mr. Chair,
Yeah.
it's a planning consideration. I mean, the board can take into consideration planning considerations, and basically, you know, it's the town's master plan. If the board doesn't want to take into account the board's master plan, I guess it's your purview. But
Well, I mean, I think there is what we do when we're deliberating, and there is the text of the decision, right? To me, the text of the decision is we approve or deny the list of factual matters on the ground. You know, this is the deliberation that we will have is a matter of public record, and it will be available to the world. I think the decision document itself, I don't think is meant to be a polemic, right? It is meant to be a statement of what you are allowed to do or not allowed to do.
Well,
The most important part of this is the finding that has to do with consistency with local needs. I mean, that's really the focus. The rest
Yeah.
of this, you can say it or not.
Right.
It's,
Yep.
a nice commentary, but it's not necessary. But that finding on consistency with local needs has to be in here.
Yep.
That's in the beginning, though, yes.
Well,
it's
no,
also
that is
page
28.
29, well,
28 and
29.
29,
29.
Yeah.
Right, but you
the
can
last
say
one
that
there,
without
yeah.
looking it over.
That's
but
the critical
22
finding.
yeah. Right, and to some extent, you know, I think 25, 26, and 27 are meant to be the lead-in to that, right? But I don't think it is necessary to the document itself.
It's not.
I mean, so 22, 23, 24, 25, 26, and 27 all have to do with sort of like town master plan and, you know, just general data about town demographics
Yep.
that, like, I don't know if we're gonna be striking, you know, just sort of descriptions of the context.
Yeah.
I feel like all of that
You're
can
not
be-
required to find that any of this is consistent with local plans. The local plan issue becomes a factor if you're trying to rely on a local plan as a basis to deny.
Well, and that, and also, you know, if this was a LIP, or if this was a, not a 40B, if this was simply a market rate thing that we were proposing, it would, to me, then be necessary
It's
to
an
connect it
argument.
to those documents, and it would make sense, right? The whole point of a 40B is that this gets to happen regardless of our local
That's
plans.
correct.
Right, that is
Right.
by definition, and, you know, look, I appreciate the commentary in here that there is a need for housing, and we will certainly talk about that when we deliberate, and I certainly have strong feelings on that myself, but that, literally speaking, this development was not planned for this spot, right? Like, you know, insofar as we have a master plan, that master plan did not say that this was going to get built here, and it was not, we have not zoned for it. That is why we are doing this whole thing. So I guess the question is there any factual, is there any material reason that we cannot strike that whole section?
22, 23, 24, and 25?
And 26 and 27.
You could certainly strike them.
Okay.
Let's do so. It's also one less page. Fewer trees.
In your version, in mine it might not be.
So many.
I hate to say it, but our record of saving trees in this project is not that
Dismal.
strong. We have created a lot of paper.
All right, my next one is on page 23, numbers 32 and 33, about pile driving and blasting. Have you, I know you didn't do any, you haven't done any geotechnical testing yet? Do you know, do you have the as-built to that garage? Is that on piles or anything like that? Do you know anything about that?
I actually don't have the as-built to the existing garage.
So you have no idea if any of this is required? Okay. Well, that should be it. By the time you do the construction management plan, you'll know, and we should address those.
covered.
Yeah.
Conditions that are covered, potential
Yeah, because
requirement.
that will not be pleasant for anyone. Those are all the things that I had marked.
Ms. Rutherford, do you have any additional questions? I know you came in a little bit late.
Yes, unfortunately I did, and thank you for your patience. It's been a day. No, mine were already addressed. Thank you, Frank, very much for all of that. So I'm here, and I'm good.
All right. Well, I think the next thing that, well, I should make sure. From the board, is there any additional commentary?
I'm good.
I don't think so. I'm just going through one more time, but
Oh, we should fix that.
I just looked
So,
at it, really.
Ms. McNeil has notified us that Ms. Rutherford's
Oh, there's
name
no
is
T.
misspelled on the first
Rutherford.
page. We should definitely make sure to fix that.
Yep.
Thank you. Ms. Barrett, do you have any thoughts or commentary on the structure of this decision and waiver?
Now, this is a structure I'm very familiar with, so
Okay.
frankly, it reads as one would expect.
Okay.
It's clear to me, and I think the comments that the board needs to have in here are here.
Okay.
And anything superfluous is not necessary and can be removed.
Okay.
Is that mainly the section that we've already discussed?
Yeah, I mean, it's not necessary for you to go through those comments. So I would just take them out.
Yeah.
There is one other section that, of discussion that we actually have skipped over, which is local and veterans preference.
Yeah,
So we discussed this a little bit last time, that we have decided to opt into having local preference. And then Mr. Killalay mentioned his desire and reasonable for veterans preference. Now, there's been some debate behind the scenes about the applicability and viability of such a veterans preference statement. Ms. Murray, if it's okay, I will defer to you in explaining to us the details of that.
So it's on page 18, it's condition number 16. And the paragraph begins with a local preference of 70% of the affordable units being reserved for residents of North Andover, employees, or those who have kids in the school district or are employed by the town. That will remain unchanged. That is something that all the subsidizing agencies recognize as being something that can be included in a 40B. It does require that the town demonstrate a need for a local preference. We also added in here, though, the veterans preference. So the veterans preference is not a function of Chapter 40B. It's a separate statute entirely that really is meant to go with like inclusionary zoning provisions, that the town and a developer can agree to provide a certain amount of, I think it's 10% of the units could be veterans housing. So we're relying on that provision of Chapter 40 to bring the veterans preference here into the 40B realm. And I've done this in a couple of other 40B decisions so far. I know my colleagues at the office have also started adding this provision in at the request of boards. In some cases, even the developer will say, I want to propose a veterans preference, and if you need there to be an agreement, I'll sign something. What we haven't seen yet with this provision, which is still relatively new, is two things. One is that we haven't seen how subsidizing agencies, when they review your decision, how they react to the veterans preference. In one project I did in another community with Attorney Smolak's partner, she had reached out to, I think it was Mass Housing, was the subsidizing agency at issue there, to ask about the veterans preference, and was told that they believe that there is a requirement that there be on-site support services provided for the veterans. And the developer in that particular case had said they weren't planning on providing any on-site services for veterans. So we worked on some language where, if that appears to be the case, the town's veteran services, the applicant would then ask whether or not the town's veteran services could serve as a substitute for those on-site services if required. So that's built into this language here. Then last but not least is, if the subsidizing agency's rules, guidelines ultimately say, sorry, we don't recognize veterans' preferences as a separate category. If you have a veteran who also happens to qualify under the local preference, then veterans can apply with all of the others. If that is ultimately the case, the subsidizing agency's rules governing these programs are going to supersede what we have in our comprehensive permit. So Condition 16 as written addresses all of those particular contingencies and ultimately says that, if the subsidizing agency ultimately says you can't do this and the applicant then therefore cannot comply, this particular provision is deemed, null and void, and the applicant will be deemed to have done all they could to comply with that particular requirement. I have not yet seen any of these 40Bs that have the similar provision in it yet progress to a point where we've gotten the feedback from any of the subsidizing agencies. So we're not sure how it's ultimately going to play out, but something I just want the board to be mindful of.
Well, it's the best we can do, right?
At this point, I think it is the best we can do, yes.
So, in other words, you've written this basically in a way that if the agencies allow it, it'll happen. If they don't allow it, then it's taken out without affecting anything else.
Exactly.
And it's really based on the subsidizing agency itself,
Right.
because I've had circumstances dealing with HLC and their subsidizing subsidy programs where they didn't require this new language. They accepted as an additional preface category veterans, as defined as statutory definition of veterans, and so it's all over the place. So this isn't yet settled with, I guess, mass housing. So.
Yeah, I fully expect we'll start to see the subsidizing agencies' guidelines modified in the future, but they aren't there yet.
It's only been since 2014, I think.
Exactly. Yeah, they've had a little time.
I guess I have a very silly question. This is just because I am a curious person and want to know how this plays out. So I guess, is there a way, if other than maybe contacting our town development office, to find out what happened to this down the road? Will it be posted anywhere? Does this, like, if someone wants to look up, oh, does this place have a veteran's preference? Is there a way to do that?
Well, I suppose a couple of things. I mean, one, we could build something into the condition that at least requires the applicant to report back to us, so we know what the situation will ultimately be. If there is ultimately going to be a veteran's preference built in, they're going to have to develop their affirmative fair marketing plan and include a lottery for veterans. That does have to be advertised in certain number of locations.
Okay.
So there is some public knowledge of it.
Yeah.
I can't say that it lands in the zoning board of appeals, inbox necessarily, but there is a way to follow that through.
I'm not going to push this, Mr. Smolak, but would it be an okay request that you just simply send a memorandum to the zoning board of appeals upon determination of what preferences are allowed and what preferences are not?
That's not a problem. I think we'll know that when the letter of final approval is issued anyway, so, which is required to be submitted.
And I'm not going to require you to come to the board,
Yeah.
right? Like, this is not I don't want to make this into a big amount of work, but more just like, hey, basically shoot us a
no problem.
one
Post the list
page.
on it.
Yeah, just so that
We
like
don't
we
need to
know.
see you anymore.
I'd just be
I do have
curious
a
to know,
question,
and I'm
though.
not trying to throw anything at you, your requirement, but even of the other ones, the North Andover residents and teachers, do they fill out the 70% that we have set aside as a preference? Or do they not do it and they go out to the open lottery? I'm not trying to put I'm not trying to add anything to this.
I think that's.
But
that's
it'd be
a
good
more
to, it'd be good,
substantial
it'd be good, no, I know,
Can I just, this is the initial, when they first open, right? This isn't,
Right.
it's just the initial opening
Yes.
Correct.
of the.
It's not in
okay.
perpetuity.
Yeah. I mean, I think when we set aside 70%, right? If that 70% is not filled, it simply goes back to the pool. So I don't know if that's so much a material thing. What I'm interested in is we may have another 40B coming up. And if we can find out before that happens, whether or not this is a viable strategy,
Then we don't have to keep putting in this verbiage.
yeah,
Right.
it would be helpful to know that. And so, um,
I was just going to say, you could just have the affirmative fair housing marketing plan filed for informational purposes with the board. But I also just want to make sure everybody understands that 70% may not be entirely local as you think of it.
understood.
Okay, just so you know, because
mean?
there's a requirement, because it's an affirmative fair housing marketing plan, there is a requirement to make sure that people from protected classes under the Fair Housing Act are not disadvantaged, if you will, in the local preference process. So if you have an applicant pool for the local preference that is not sufficiently mixed in terms of the regional composition
Yeah.
based on race, then you have to go into the non-local pool and bring people in who are non-residents in order to bring the minority percentage up to the regions. So sometimes you end up
Yeah.
with local preference
But
that's
we
not
may-
entirely
But
local.
we may have that mix
You may, anyway,
available as well. and
that's correct.
I'd want
I just
all
feel
of them to
compelled
have
to
that
say this
opportunity.
because sometimes people do not understand, so
Yeah.
just to
No,
avoid any
thank you for
surprises
pointing
later.
that out.
Yeah.
Did you have another question?
No, I just want to make sure that it was just the initial,
Yeah, it is.
All right. Ms. Murray, any additional items that you feel we haven't addressed thus far?
No, Mr. Chair.
All right. So then at this point, I would like to open up to public comment. And before we do, I just want to acknowledge, we today received a memorandum from Mr. Jim Holland, who has spoken many times at these meetings, expressing his point of view. This will be entered into the public record. I think one aspect that I do, so two things that I wanted to, that I do want to specifically reference. One is that he went and helped and dug up the 1984 special permit, and that document was submitted as part of his public comment, and so that will be in the record, and folks can look that up if they're interested in the text of that 1984 special permit. The other piece is that a comment that he makes is, and I'm just going to quote him directly, in addition, I'd like to ask the board to review the prior meeting record for items that were expressed as intentions. It is my understanding that there is nothing preventing a sale of the property with a 40B permit. The town should have more than the current applicant's intentions on the project. A new owner might not have the same intentions. I think there's sort of two ways to view that discussion of intentions. I think one piece is that if this property were sold off to someone else, what could they build? And Ms. Murray, correct me if I'm wrong, but it would be limited to what is in the text of the decision, regardless of who owns the property.
Correct, and the board, they can't just sell it in the open market.
Yeah.
They would have to also get the approval of the subsidizing agency, because the new entity that takes control has to qualify as being an eligible entity to operate a comprehensive permit development, and it would also have to come to this board as well for approval.
There was some language in there about that, wasn't there? I read something about assigning it, or that sort of thing.
There typically is some language that, there's a process once you actually approve a comprehensive permit. There's a process for modifications, and they're either categorized as an insubstantial modification, minor, or substantial, major. And a sale to another entity that's deemed by the subsidizing agency to be, an eligible entity to hold a 40B, a simple transfer of the comprehensive permit to the new entity by itself is typically not a substantial modification. So they could literally step in the shoes of the applicant we have before us and exercise the 40B exactly as granted by the board. Or they could come back in with a more substantial modification, which is going to trigger a whole new public hearing process with this board.
So even if it changed hands and someone else were executing it, unless it were this plan, they would have to come back.
Probably. The regulations go through, it's not necessarily a hard and fast rule, but there's a list of things like in the regulations of what may or may not constitute a substantial modification. And then there are things that don't fall into any of those categories that falls to the discretion of the board. But even an insubstantial modification, they'd still have to notify the board. And the board would have to decide, we agree, it's insubstantial, we don't need to have a public hearing on it. You could take no action on an insubstantial modification, and after 20 days, it's deemed part of the comprehensive permit.
Right, but specifically to, if they were to sell it, they would have to, does comprehensive permit follow the sale, or do they have to assign the permit to, because I thought I read something in the.
It's called a transfer at that point, that the comprehensive permit can be transferred to a new entity, provided the subsidizing agency approves it, and then, of course, the board would have to agree as well.
Yeah. But that's covered in the decision,
Yes.
right?
And then,
Yeah,
but
so-
once it's actually developed and built, then
Oh,
the
after-
comprehensive permit runs with the land
Yeah, so once it's built, they can sell it
to
without.
whomever, right?
Yeah, and so that sort of brings me to the second piece, which is to say that insofar as the applicant has asked us to take anything on trust or faith that something will be completed, I think Mr. Holland's concern is that we will not, that we cannot necessarily expect that if it gets transferred. And I think the first piece is what you just talked about in terms of the construction of the site. And then the second piece is after the site has been built, if it transfers hands.
There's verbiage about that too, about successors and whatnot.
There is, and there also, there is text in this document about some things, about how the building is to be maintained, right? So we just talked earlier about the stormwater clause to say that the town can come in and basically, fix things and charge the owner if we feel that it has fallen to a substandard level. Similarly, we have the tree protection plan. And so I think there were cases where those ambiguities came up, and I actually do feel that the board did a fairly good job of making sure that we nail those down as much as possible. I think Mr. Smolak made a comment in the last meeting that this is a very long document. I think that is correct. But that, and part of it has been to try to remove some of those ambiguities, but on the other hand, it is a long document, and we are instituting a lot of restrictions about the property, both during and after construction.
Well, we just made it a little shorter too.
We did make it a little bit shorter. We did. But it is still long. All right, with
So
that.
what kind of items would Mr. Holland have been referring to as far as intent or trusting them?
He does
That is somewhat ambiguous, but
Yeah.
I would assume
I know
like
stuff has come,
a bigger
been
or
talked
a worse
about.
project of some sort. I don't think he would object if it was made a smaller project.
Yeah, so he does talk about there are conditions where the applicant's responsibility for resolution is very limited. And in particular, looking at traffic studies, right? So if, for example, we find that traffic and pedestrian usage is much higher than was outlined, the remedies that we are allowed to require of the applicant are limited to signage and markings. We're not allowed to require that they substantially change the nature of the roads, or that they fund a substantial changing of the nature of the roads. So there are limits to what we are asking, the liability we are assigning to the applicant in those cases.
Right.
But that's not really about intentions, that's about how
That's
things
sort
play
of-
out.
Right, that's sort of,
Yeah, that's not about intentions. Okay, all right, with that, I'm going to grab the list.
You did get a copy of the public comment, right, from Mr. Holland?
Yes, it's right there. So no one is written on the list, but I see some folks in the audience. If anyone would like to come up and speak, I'm sure you'll be very sad I did not bring the shot clock this time. And so we'll have to rely on a cell phone timer, but if anyone would like to come speak, you're please invited to. Please. And welcome back, and please identify yourself for the record.
Kelly Sarney, 39 Prescott Street.
Welcome.
I have a favor to ask of Mr. Steinberg, and we've been looking at the landscape plans, and we're going crazy trying to figure out these 17 trees, looking at them. Is there any way to mark them somehow so we know which ones are staying, just so we can get a better visualization? We're not asking to change anything
Sure.
else. We just are trying to figure out which ones are staying, especially where near the parking garage is gonna be. That's all on that part. My other question is this substantial, insubstantial change. Say during one of these phases that they're building their project in, God forbid, they find something that makes it a little harder to do what they wanted to do. Does that constitute as a substantial change to come back? Or does that not?
So that's a very good question. I'll follow up. Do you have anything else before I?
I don't think so.
Okay. No, because that's a really great question. So first of all, Mr. Steinberg, would you be willing to like tie a ribbon on the trees that we plan to keep at some point to help the neighbors just understand what's going to stay and what's going to go?
Yeah, I'm fine doing that. I'm wondering if it's most helpful during the construction management when we're setting up the site. I think it would make sense to walk through the location of fences, trees that are remaining. Things
Yeah,
like that with
I think
professionals that are all there.
I don't want to speak for Ms. Sarni, but I would guess that what they are looking for is the ability for them to be able to plan on their own too, right? So that if they see a gap that they want to build some fence or plant a tree or something like that, that they have time and the ability to do that. And so as much warning as we can give them is probably ideal. Ms. Murray, this is a great question and one that I am sure is fraught in many a court case. What constitutes a substantial change?
Beauty is in the eye of the beholder. Yeah, as I said, the regulations do provide some guidance to us as to what types of things may constitute a change. And the changes would have to be, an increase of a certain, I think it's, and forgive me, did not bring my regulations with me tonight, but an increase, say, in the number of units, I think by more than 10%. Or if you are increasing the size of any of the units, a change of tenure. If they were going to go from rental units to condominiums, that would be a substantial change. Things of that nature.
If they needed to change a setback by any amount, would that constitute a substantial change?
In my opinion, it would, because I
Okay.
think it would require a new waiver.
So if they said, I think to Ms. Sarni's point, if they decided, actually, instead of a 17.5-foot setback, we need a 14-foot setback, that would be a substantial change.
Correct.
What
Now,
about the
The board gets
step-backs?
to determine that. The board gets to make that determination. Is it substantial?
ultimately, yes, but we did include, and I probably don't have the right paragraph, I think at one point it might have been condition 38 with field changes and some shifts.
Yep.
That we did allow some flexibility for some minor alterations, which, like I said, we typically refer to them as field changes.
Paragraph 5.
Paragraph 5, how did I get 38? Okay.
At the bottom of paragraph 5, I think.
Paragraph
Discusses
5
minor
of
changes.
Oh,
what section?
It's gotta be
It's
this
under the conditions.
conditions.
Page 16, 15 to 16. Of my draft, anyway.
Okay, so
Yeah,
it's-
minor changes to the site development plans and final plans, e.g. changes that do not materially affect the location of or increase the height or massing of the structures or increase the number of units contained in the residential buildings, shall be submitted to the building commissioner, who shall have the authority to approve such changes as immaterial changes. If the building commissioner determines that the proposed changes do not conform to the requirements of this comprehensive permit, he shall so notify the applicant, and the applicant shall either bring the plans into conference with the decision or seek modification in accordance with 760 CMR 56.0511, as described above. So,
So that would include basically all of the dimensional things outlined in the current plan.
so the building commissioner would have the discretion to say, this is a substantial change, you need to go back to the board and discuss this
Or that it's
modification.
The way,
sufficient,
The way I read it is that the building commissioner just determines if it conforms with the current comprehensive permit or not, and then it comes to us if it doesn't.
Is
That's,
that correct?
I mean, that's how I
Yes,
would read it,
I
and
was
that's how I
actually
would interpret
thinking, I was actually thinking of a different paragraph where I thought we built in some minor field changes.
is that like things that were not explicitly mentioned here, but are listed on the site plan that the building commissioner can just say, oh, yeah, sure?
Yeah, something shifts, 2 inches to the
Right.
left or to the right.
I remember what you're talking about generally. I
Um,
don't remember exactly where it is. But I do think that one line, if the building commissioner determines that a proposed changes do not conform to the requirements of this comprehensive permit, he shall notify the applicant, and the applicant shall either bring the plans into conformance or seek a modification. I feel like that covers pretty much all the big stuff, the dimensional requirements that were outlined pretty clearly, I would say, in the comprehensive permit.
But
And
also
then-
something to just bear in mind with respect to the regulations, the applicant has to notify this board of a change, be it insubstantial or substantial. This board then has 20 days to decide whether you feel it is substantial or insubstantial. And if you determine it's substantial, we notify the applicant and we're off to a public hearing. So there'll be plenty of public input about any sort of substantial change.
But we don't meet every 20 days.
So I was going to ask, is that something that can be determined at the discretion of the chair, or is that something that we would have to organize a meeting to determine?
There is nothing in the regulations about just delegating that to just one individual, so it just calls for the board. But I have gotten extensions from applicants in the past for that 20 days to say, that's great, you filed this modification request, but the board isn't going to meet again for 23 days.
Yeah.
So we get an extension and we still satisfy that period of time for the board to be able to evaluate whether you think it's substantial or insubstantial.
So if we get a notice and we have a meeting in the next 2 weeks, then we can talk about it at the next meeting.
Yes,
But
you
if
could.
it's like we just had a meeting and we're not going
Exactly.
to, then, okay.
Okay.
If I may, I mean, whenever that's come up in my circumstance, I always advise the client to time it for the board's regular hearing or meeting date, so I've always done that, so.
Yeah.
And those don't need a public notice and all the other,
No, not for you to just consider the modification
yeah.
request. And if it's an insubstantial modification, you can just approve it at that meeting.
okay.
It would have to be listed on the agenda
Right.
under open meeting law, but that's,
But there's no
But
legal
not
ad or
sending
anything.
things, yeah.
Right.
Okay. All right. Is there anyone else who'd like to come forward? All right, welcome, and again, please identify yourself for the record.
Yep. Good evening. Andrew Sarni, 39 Prescott Street.
Welcome.
I just wanted to follow up on a previous inquiry I had about the financials. I had submitted a purchase and sale from RCG to East Mill Housing, and it was my understanding that like a related party, land value would not be accepted as face value, that there should be a financial review done on that, and I haven't heard back or haven't seen any,
So,
the land value being vetted. As far as, I'm not a developer, but when I look around, a parking parcel, locally in Methuen or something like that, maybe $250,000 per acre, where $10 million seems highly inflated. And that would obviously contribute to the limited dividend calculation post-construction that I'm concerned, everything's being pushed through here at this 280, that's very large.
so maybe
one of my
Ms.
questions.
Ms. Barrett, maybe you're the best person to ask about this. So, in thinking about, I think Mr. Sarni is concerned that the listed value of the property has been inflated in such a way that requires them to then have more units or more profitability in order to make the development viable than is actually necessary. How do we think about land ownership in these transactions when it is already owned by the applicant before the development starts.
So that is a determination of the subsidizing agency. There is a pro forma review that occurs during the process of what becomes a project eligibility letter.
Yeah.
And it's really up to the subsidizing agency to determine whether or not what the applicant has submitted is acceptable and sufficient
Yeah.
for purposes of determining profit. If there are subsequent questions, the more, I think, grilling aspect of 40B is not even this process, it's what happens in final approval. So if there's any question at all, it's going to get vetted more at that level, but it's the subsidizing agency that makes that determination.
They're
So when
privy
does
to the
that occurs
financials.
after this?
No, they would have done it as part of the project eligibility application, because the applicant has to submit a pro forma, they have to submit, documentation for the pro forma, there's an appraisal done almost immediately, so the subsidizing agency looks at that before this ever comes to you.
If I
And
may,
so they have already determined at this point then that valuation is at least reasonable.
Sufficient for going forward to a comprehensive permit, yes.
All right, so Mr. Sarni, does that answer your question?
Kinda, I don't know, if they're gonna use that figure in the end, post-construction, and it hasn't been fully vetted, or as is value, then that doesn't fully answer my question, but I
Well,
guess.
I guess what is your, so I guess one way to put this is that we have not requested a pro forma
Right.
out of the applicant, right? And that is because we have not gotten to a local concern, by which I mean like a specific relationship between our laws and the waivers that are being asked that have led us to say that we cannot allow this waiver. And they have then said, well, we cannot go forward with it, right? Because we can't ask, we discussed multiple times at these meetings, but like,
We could just ask them.
we can't ask them for less to get down to the line of profitability. That is expressly
Yeah,
forbidden
No, not
by
looking at that,
40B.
we're just looking at realistic, numbers where if they're inflating the value to increase the number of units, then that's not fair.
Right,
We
but
also
that's
can't
not a
just-
value that we have entered into our equations at this point.
We can't ask them to open their books, just, hey, show us how this money works. We can only ask for a pro forma if we get to a standstill point.
Right, well, there's
Whereas
been
in
lots
the
of local
application,
concerns.
to get it through to this point,
Right.
a pro forma was done by the state of Massachusetts, that presumably at that time, they did some due diligence and determined that either the $10 million was a real number, or that they felt that the project as a whole was enough to make that work. We don't have
But
access to that.
We can't ask them to cut the number of units in half because they're making too much money.
It's
So
actually
if
part
they-
of the findings they have to make,
Yeah, no, I'm not,
project.
not asking, I mean, we're all for the affordable housing, we think this is a great location for affordable housing, just not at this 280 unit footprint, that it's totally unrealistic as far
Right.
as all
But we
human scale
can't ask them to-
development,
we can't ask them-
reasonability.
But we can't say, you're making too much money out of it, so cut the number of units in half.
Right, but all the local concerns with the traffic and the scale and the public safety, could be things that would push back to reduce it.
So we also discussed this last meeting, which is that I think the definition that sort of naturally comes to mind when you say local concern is a much lower bar than how the courts view it. The court's definition of a local concern is an extremely high bar, one that, as Ms. Murray told last time, she's only seen 2 cases where a court has accepted a town's local concern. And so it is actually a very, very high bar that we're being asked to meet. And so saying that, we don't have.
Pedestrians that you're gonna look at after it's built, if
So
there's
the other
pedestrian
factor in this
safety
is that
issues?
the town did employ expert peer reviewers to look at all of the data about what could happen. So for us to say that we just don't believe our own expert peer reviewers, that the town has paid money to engage, and that we think it's going to be catastrophically worse than what they say it's going to be, is hard to uphold in court.
Okay. And then the last one was, under normal 40B process, is there, like the PEL said, 230 units was the local need, and now the developer and the town seem to want to have it greatly over that. Is that normal how the process works?
So there is the number of units that we would need to achieve safe harbor, right? So that's to achieve that 10%.
At the time of the application?
Yeah. It turns out that the way the 40B process works is that the applicant is not limited to only getting to safe harbor. They are allowed to set aside a development that is larger than that. And if the subsidizing agency feels that that development fits where it's going, then that gets to move forward. So that's part one. Part two is that there's a more complicated discussion about, okay, once we get to safe harbor, how do we stay above safe harbor, right? And there's a bunch of things going on in there. One of them is that when we approve this, the applicant has 3 years to begin building. That we get to put those units in our affordable housing inventory to count for 2 years. But then after 2 years, or after 1 year? Is it 1 year? Sorry, I apologize.
It's okay.
I'm already getting crossed up.
12 months.
12 months, okay, 12 months. So we get it for 12 months, and then if they haven't started building those units, those come off of our books. And so what can often happen is that we get something that gets us to safe harbor, and then it dips below. And then in that dip below, another project can come in and fulfill that. So that's part one. Part two is eventually these units come off of our inventory. And so we have developments in town that are aging out of this program and are coming off of the inventory. And so that means that then our affordable housing count will eventually go down.
We also are always building new, there's always new like single family market rate housing being built just generally around town. All of those change the ratio of affordable to total market available housing. I believe last week we had like a whole breakdown of what the anticipated need would be. And even with this project, we were actually under what we would probably need to be at
in like 3 years' time, I think it was.
I saw that. Did that include the child block?
Yeah.
How
148?
do these come off of the affordable housing?
I think it's after 40 years, is that correct?
Because there was language in here pretty much saying it's forever except for certain circumstances.
So the present standard is that the units remain on the subsidized housing inventory in perpetuity or for as long as the project does not comply with local zoning.
Right, so if we rezone it and make that comply, then they could get it out, right?
Yes. Now, there are some older projects that were built under different programs that did have some expirations. Or there was a time when if an affordable unit was foreclosed upon, then the affordability did not survive foreclosure.
Right.
So there are a couple of other elements at play.
Yeah. So
Projects that were built under, say, the low-income housing tax credit, they age out, right? So we might be losing those kind of.
yeah.
But
not these units.
But
no,
this
no.
one's going to stay.
I'm not talking about these units specifically, but that we have
all
things that are coming off of our books, and that as they come off our books, we need to be able to replace them to remain at safe harbor. And so I guess what I'm trying to say is that there's a few pieces to this, right? One is whether we're at safe harbor now, whether we'll be at safe harbor when this is approved, whether we stay at safe harbor for the long period of time, and that is over the 1 year period, and then as you said, at the 2030 census when our population is also increased, whether we remain at that. And so we're trying to stay ahead of those things so that we can structure ourselves to remain at that place. Also because it is good to be having sufficient affordable housing, but it's a complicated equation.
Right. I just think that would be all town management and development that you would account for that. We don't have to use this Prescott Street as the release valve to get to the index over the number. That doesn't seem like it's the local need.
It sounds like it won't even get us there from the numbers that were outlined last week. And I believe those are on the town website, right? Your presentation?
It didn't include the 148 at China Blossom,
that
which is a lip.
presentation was included with the select.
That will all go on the affordable housing.
Oh.
We don't get to choose where they happen.
Right.
That is the
there
definition.
has been a lot in that area, and it would be great if it was somewhere else, but, you need a developer to come forward and say, I want to do it in this other area of town.
Or you need us
Wait.
as a town to have zoned for that land.
Yeah.
All right, thank you.
Mr. Chair, if I could just add one item in terms of valuation. When the project eligibility letter application was filed, Mass Housing undertook an independent third-party appraisal of the value of the property. And so the value that could be used is the value of the third-party appraisal or the purchase agreement. Well, actually, it's the value of the third-party appraisal plus reasonable carrying costs. So that was a change that occurred like 20 years ago because of concerns that were just raised when the New England Fund changed. And when the former DHCD started issuing these letters instead of banks.
All right, thank you.
There was a question that was wondering if that was a public record, but I'm not sure if that's something that you would even know.
Yes,
Mass Housing
Mass Housing has it.
Project eligibility letter included, it's in their records, the appraisal. I don't know if that's published or they.
Could be.
All right, are there any additional public comments? Okay. So I think the first piece that I want to ask here, and I apologize because it's a silly logistical question, but the first one is, Ms. Murray, we made a couple changes in here. Are these changes that you feel can be completed by, if you had to revise the document, can be completed by Thursday, end of work, basically?
Yes.
Okay.
This Thursday, 2 days.
Yes. I think the second question is, if we voted on these documents as they are sort of written up with the knowledge that the comments that we made are coming forward, do you feel that that legally we are, we're in safe territory for that, and that we're not causing any trouble of people not being fully informed or things like that of what they're voting for?
No, I mean, the only revisions I can make is at the direction of the board. So if you vote tonight and then instruct me to make the revisions consistent with your discussion this evening, that's my limited scope. I can't.
Okay, but no, it's more
include
that
something new.
saying that and doing that is sufficient from a legal perspective.
Yes.
Okay.
Like, we could, in theory, vote tonight on the decision with all of the strikes that we just outlined.
Yes.
All right. I think my third question then is for the board, which is that do you feel that you understand these documents well enough and that you feel that these documents have what is necessary for us to deliberate and vote?
Yes.
Probably. I mean, we haven't really started deliberating yet, so it's hard to
Well,
say, but yeah.
right, but once we start deliberating, we cannot go back to the applicant.
Oh, I mean, you
Once
see,
you close the hearing.
Right, because
Right.
we will close the hearing and we'll
is there
start
anything
deliberating.
else that needs to be done?
Right.
And we can't make any more edits to the decision after that.
So we can make edits to the decision, but we cannot get input from the applicant.
Right.
And so if we create one that makes it unviable, we create a lot of trouble for
I
ourselves.
see, yeah.
And so if there's anything meaty, we should do it before we close the public meeting.
I can't think of anything.
I think the question is there information the board needs in order to reach a decision that you don't have now?
You don't have to answer because I can keep
Yeah,
going around the
just-
room.
Right,
As
but I'm
you
just saying, I mean,
described.
that's
Well,
the issue.
I did want us to respond to Jim Holland's other letter that he
Okay.
sent out regarding the parking garage, and he was requesting a health and safety consultant to comment on it and whatnot. I don't have a response. I just didn't know if anyone else did.
I thought our response was to add the health department to the construction plan for review of the construction plan. Maybe I am
Well, that's,
conflating two
that's
different
not,
things.
that's not really, this is more about what the garage is, you know, the pollutants or toxins
Oh,
that
I
might
see,
be
in the new
generated from that
garage.
many cars parking in a garage. And he requested that we hire a independent, health and safety expert to comment on it.
Do you feel like you can't vote on this until we do that?
I just feel he sent in a letter and we should
Yeah.
comment on it. Maybe we can do it afterwards, but
So I think we spoke about this at the last meeting, actually, quite a bit.
I thought this letter was after the last meeting.
Yes, but it was reiterating something that he had brought in person as well, right? So he, in particular, from what I remember, had requested that we do, for example, dust collection, right, sample collection, and measure air quality, and we
I
do
think I said
asbestos
that.
testing.
Yeah, that was
He said the asbestos, yeah.
Right. Well, okay. So yes, you were part, but I think where we came to at the end of that discussion is that we were we were creating a system that was, I think, both burdensome and maybe not necessarily effective. So my leanings were towards not substantially changing the plan beyond the changes that we made in this document here about having the health department be involved, and following the standard rules about sampling and dust collection and stuff like that. But if you
Well,
do
his
you
question
feel
here
that,
isn't about the construction period.
Okay.
It's about
Having a parking garage.
an operating
at all.
garage.
oh, I'm
with that
sorry,
many
I'm
cars
sorry, I was misunderstanding.
being
Okay.
parked in it, and its impact on the community.
I see. Okay. Do you have anything that you would like to comment on that?
No, I don't know what to say about it, to tell you the truth.
I think,
I just
my
wanted it to
understanding, because I
be
do think we
at
still
least-
talked about this aspect of it, my understanding is that was considered substantially unusual to request.
But, so.
Maybe Judy, do you have you come across that with a parking garage before? or-
No, I have not. I was thinking about other cases. I have not seen that as a condition anywhere.
Our health department did review and comment on the plan, right? So he's sort of
plan as a
asking for something
Yeah.
separate, but should we be satisfied with our health department having looked at the plan? Versus an independent consultant?
I would accept the health department's comments. I would only suggest an independent reviewer if you thought the health department wasn't capable of either responding to that matter now or through some type of monitoring later.
I don't know enough about our health department, but
Right.
I guess I would have hoped that if they thought it was outside their expertise, they would
They
have.
would have said something. I mean, departments do that. If they feel like they can't
The
adequately comment, they tell you.
The other thing, Frank, is I think the existing parking, if my numbers are correct, like 594 spots, right? That was on a plan earlier. The new parking garage has 362, so there's less parking in the garage than is present there today. And I did read one of the highlights that Mr. Holland had sent, and it kept referring to an urban parking garage. And it never defined an urban parking garage, but if you ask Google what an urban parking garage is, it's underground parking or mostly enclosed parking. So I think that was part of his concern, where this is, I think, is more open garage. I don't think that concern is
So it
as,
doesn't have a point source of the exhaust
yeah, I
being
think, yeah,
concentrated.
right. So I think the fact that there's less cars being parked in the parking garage than could be parked in the existing parking garage at this point. But that,
The only thing I could see being helpful is if we wanted to try, see if there was like a recommendation that there be like idling restrictions placed on vehicles in the parking garage. I think if the health department didn't raise red flags and ask for an analysis, then.
I think Judy's actual comment, though, because I thought one of the big things he was asking for was the independent health and safety consultant, but Judy pointing out that the health department and haven't looked at it, and it would be upon them, and they typically do, comment if they feel they need a consultant to review it and whatnot, so I think we have to rely on that, I guess.
Health boards have tremendous authority in Massachusetts, and if there is a concern, I guarantee you they would be able to investigate further, regardless of what your comprehensive permit says.
Yeah. All right, I just, I want to make sure we give them
Yeah.
all the opportunity to
It's worth
say his
go-
point for us
yeah.
to respond and
Worth going
get
through.
our professional input on it, so that.
Ms. Rutherford, is there anything additional that you were looking for?
I have everything that I need from the applicant at this point in time.
All right. Ms. Craig Coman, coming back to you.
No, I still haven't been able to think of anything that I think will need to get hashed out.
All right. Mr. Smolik, Mr. Steinberg, is there any last comments, last words, famous last words that you would like to have?
No, I would say we appreciate the long process been involved in all this, and all the care it's been put on into the details of the board's diligence on this, and the number of conditions and things like that. I think are reflect the painstaking care that's been taken to review this project. We appreciate that. We've it's a lot of conditions to follow in an administrative sense, but we defer to your judgment, and we intend to stand by the what we've produced here and the way we've answered your questions and the way we've modified the project.
I think Mr. Steinberg took my words.
All right.
I have nothing further to add. Thank you.
All right, thank you. All right, I guess here's the moment. Do we have a motion to close the public meeting? Sorry?
Public hearing.
Public hearing, I'm sorry, public hearing. Close the public hearing. I want to make sure we get it right.
Reference a 40B or? All right, so I make a motion to close the public hearing.
Seconded.
All right. Ms. Rutherford,
Aye.
Mr. Killalay,
Yes.
Mr. Testa,
Yes.
Ms. Craig Coman,
Aye.
and I am an aye. All right, we are closed. Mr. Smolik, Mr. Steinberg, you're welcome to sit down and enjoy the rest of the show.
Maybe. You're not required to enjoy it.
Before we get started down this path, I want to thank some folks. I want to thank the public, especially the folks that came here and spoke. Many of you spoke at every meeting, and I know you will feel that that we have not addressed your concerns, but trust me, we have heard them, and I appreciate your input. I really do. I would like to thank the applicant for going through all of this. I know this is not an easy process, and it is not an easy process when sometimes your board has never been through something like this before. I would like to thank our peer reviewers. We had a lot of excellent peer reviewers for architecture, landscape, for civil, for stormwater, for I know I'm missing traffic. I know I'm missing more things, but that input has been extremely valuable and has contributed a lot to the way that we have shaped this agreement. I would like to thank our advisors, Ms. Barrett, Ms. Murray, and Ms. Israel. Thank you so much. I definitely would not have made it through this process. We would not have made it through this process without your help, so thank you. I'd like to thank Ms. McNeil. You did not know you were signing up for quite this much, and so I really appreciate for you that you did not rage quit on us. So thank you. And thank you to these board members. This has not been easy for us. Likewise, we all, I think, thought we were signing up for a once-a-month commitment, and it has been substantially more than that lately, and we have had to learn how to be every board in this town all at once. That is not an easy task. Hopefully we've come through it with some additional skills and a little bit more understanding about how the sausage across the town gets made. But I thank all of you, not just those of us who are here in this meeting, but also Ms. Jacobs, who was through many of these meetings and then unfortunately right at the end had to drop off. But I appreciate all of you and all of your input. I've really appreciated your different skill sets and what you've brought to the table. It's actually been really nice actually learning about all of your skills, because through this process I've learned that your specialties and the things that you understand much better than I do. So with that, the matter at hand, I think...
Can I just, since you're doing all the thanks?
Yeah.
I want to thank you, because you've carried more of this load than any of us here on the board, and must have taken you a lot of time and effort and some
And you
stress.
also haven't done this before.
I also have not done this before, but I have had an enormous amount of help, both from you folks on the board asking great questions, but again, from our advisors. They've been enormous amounts of help. I have asked a lot of them, especially Ms. Murray. You've had to do a lot on a very tight schedule, and so I really thank you for the amount of writing that you've done. On the issue at hand, I think, the abutters have made very clear their feelings about this building, and I think they are right in a very important, substantial aspect, which is that this property was never designed for this purpose. This area was never zoned for this purpose. And that is, for better or for worse, why we are going through a 40B process. 40B exists because communities are not zoning for the housing that they need to have, and they are not setting aside the land that they need to in order to have affordable homes, in order for our communities to be affordable. I grew up in the town of Needham, which between 1970 and 2010 shrank by 3,000 people, while the Boston area doubled in size. And I watched, as I grew up, that town turn from what was before I was born, a middle-class town, to one that is very, very difficult to afford to live in. And it is a town that I could not afford to live in, and that is part of the reason I live out here in North Andover, which I love this community, but it is, it was also a bit of math. And one of the things that I love the most about North Andover is that we are an intergenerational town. If you go to the North Andover Historical Society and you look at the map from 1648, you will see a lot of the same names that are still in town, still bickering with each other. And I think that that is a wonderful thing. But also that if you talk to those families, you see that their kids are not living in North Andover. And that's because it is becoming harder to live here. And so we as a community have had ample opportunity to set aside land and to say that this area is zoned for housing, is zoned for multifamily housing. And we have not taken that opportunity to do it. And 40B exists to basically tell us, well, if you're not going to do it, then it's going to happen to you. And so we've spent a lot of time trying to talking about the impact of this site on the surrounding neighborhood. And I think that that's very important. And I have, in working with this board, tried to figure out ways to make it as, I don't want to say minimally impactful, but reduce the most severe impacts of it on specific individuals that we could. But we don't get to say no because of the choices that we have made as a community. And so that puts us in a spot where this is in front of us. And I think the flip side is that we do need to think about who gets to live here. right? We talk a lot about who lives here already, but we also don't spend enough time talking about who gets to live in that home, who gets to move into our town because we build these things. And that is when we are told that we have to weigh local concerns versus the need for housing, what we are saying is we are weighing the experience of the people who live here now against the ability of people to come and live with us. And, you know, to what I was saying about being an intergenerational town, to some extent we get to choose, do we get to keep the neighborhood looking the way it has been, or do we get to keep the kind of people that we've had? And we don't really get to choose both. So with that, I would like to open it up to the board, and if anyone would like to get us started on their thoughts.
I'll volunteer as tribute. I mean, I don't think that this project is exactly the way any of us, other than the applicants who are in the room, would have envisioned this project if we just were given the property and said, do something good for housing on it. But it's, you know, that's not the question at hand. The question at hand is, as the chair said, what can we ask for that will make this better for us and better for the people who are bearing the biggest burden of the decisions that the town as a whole has made. Because this is not next to my house. It's not next to any of our houses. And I hope that it is felt and believed that we do care about that and understand that. But at the end of the day, this is the project that we have to look at. And honestly, it seems like it would be a very nice place to live. And I think once construction is completed and landscaping is there and it doesn't look like a construction zone, I don't think it will be a drain on local property values. I do think that during construction it will be tough, for sure. I also think that the town likely will have to make substantial improvements to the traffic flow of these roads regardless of this project. I think they have had to for a while. I think I've mentioned in previous meetings that my own boss got into an accident at High Street in Prescott. Like, it's a terrifying intersection, and of course this is not going to make it better, but it also needs improvement regardless. And the town is planning to do some level of improvement in this area, and we can all put more pressure on them to do other improvements as well. I think that's generally sums up where I am at.
You guys were very eloquent. I would have to really prepare something in advance to speak like that, and I haven't. I think the people who live near there are bearing a big part of the burden. I think they're really frustrated and stressed by it. I also think from some of my experiences that I've had in the past is that once it is done, they may not find it as bad as they anticipate it to be. You know, on paper and in discussion, it can be more daunting than what reality may be. So I'm hoping that that helps and it's not as bad as they think it's going to be when it's actually in place. But I really wanted to try and, you know, get modifications made to the best that we can, but to help them, but every time I ask questions, I, learned that it's really outside of our control unless we want to, get the town involved in a lawsuit that we're not going to win. I'm a little challenged with this one. So maybe as we wrap things up, I'll, get a clearer perspective on where I stand on it. But that's where I'm at.
Well, I guess when it started, my biggest issue was the 16-foot setback in the back there. And I think we've tried to make, a little bit of headway. We got the 35 feet there, the step backs in the front edge there where it's going to not be to appear to be as tall. And so I appreciate the applicant's efforts on that redesign. And again, I don't think it's perfect by any means, but I will echo Frank's last comment about, the town and the burden of, fighting something that we're probably not gonna be able to win.
Ms. Rutherford, do you have any thoughts?
Thank you. I do have one or two. It has been a fascinating, if not overwhelming process, and I want to thank everybody who's been involved in it, who's answered questions, who's offered commentary, who's appealed to anyone for changes and for all the compliance with changes requested and information requested. It has been an interesting learning experience. It is very tough to know that you have to make a decision that is going to be impactful on the town that you choose to live in, as well as not directly on your own self, because I'm not next door to it. That said, I think that we as a board have done what we can do within the limits of pretending to be every other board and department in the city, to get us to a place where this should prove to be an asset to our town as we grow versus a detriment. And that if there are issues, I think we've put enough, if I understand all the waivers correctly, and I'm still absorbing them to some degree, that we've put enough stopgaps and opportunities for corrective action in there to keep it from getting out of control. So I'm looking forward to the deliberation.
I think it is very tough to be someone who bought a home in a neighborhood, I think looking around and saying, this is perfect and I never want it to change. And I think that is or I never want it to feel different than it feels. And that is a tough thing to have that change then sort of thrust upon you. And so, as others have echoed, I appreciate both that this that the burden of the construction and the existence of the building falls disproportionately on a small number of our citizens, and that those citizens are not us, and that puts us in a position where we cannot fully understand how those folks feel. We can imagine, but I don't think it would be fair of me to say I know how it feels, because I don't. But again, I keep coming back to the fact that the folks who get to live here never get to really have a voice, because they are by definition not residents right now. They don't come to these meetings because they don't yet live there. And so we kind of have to speak for them and think for them as we consider these things. And
Hopefully 70% of them will be here already.
sure, but even so, they were not abutters, right? They were not people
as
who
far
were
as
going
abutters,
to
yeah.
come to a zoning board meeting and come and stand and say, I'm going to live here, because even if they wanted to, they'd still be entered into a lottery, and who knows if they would actually get a spot, right? And the fact that we're going to have a lottery gives you an idea of how much the demand is. You know, I've heard various accounts over the years of how long the waiting list is, and I believe it's hundreds, if not thousands, of folks in waiting lists for affordable units in the area. And so the need is really, really strong for more housing, and we do need to consider it in reference to that. Like Mr.
Sorry.
So I was gonna say, like Mr. Testa, I think the biggest things for me were the closeness to 39 Prescott, and certainly when we went for the site visit, it was very clear that that was much too close. And so I appreciate that the applicant pulled back, even at the cost of about, I think it was about 16 units. 16 units, yeah, you're right. And then the step backs, I think, help a little bit. I think, as one abutter has said on a couple occasions, that is, in his view, nipping and tucking, and I certainly appreciate that. But I think it is actually going to have a bigger impact on the appearance than I think people would realize. But yeah.
I do think we've had, not the literal people most likely who would be applying for these apartments, but we've had what I would say could be stand-ins, where we, as a zoning board, have had a number of, before the ADU, legislation went through, people who were building in-law suites so that they could move into them and their grown children could take the rest of the house with their children, new babies and whatnot. We've had people who make their houses, single-family houses, into multifamily houses so that they could have their adult children live with them. Like, this process generally is happening in a lot of different places, and zoning board actually does see a lot of those people. And I would say, it's when you get to see the people's faces who are applying, and not, no offense to the developer, but not developers, but you get to see the actual people the faces of the people who would be living there. It is a little bit of a different feeling that unfortunately this process does not get. But at least we have seen it in many other cases where I do think
Yep.
that it would be very similar. The people who need housing in all sorts of different ways, whether their parents already own lots that are big enough to have an accessory dwelling unit on it in North Andover or not. So, I think that's a part of our zoning board experience that we can bring to this too.
So since this is a deliberation process, Mr. Killalay, is there anything that we can help you in terms of helping firm your decision one way or the other? Is there a question that you have in your mind that you're weighing or trying to understand?
How many votes do they need?
So the answer to that is that they need 3 out of 5. So this is not, we are all independent entities. We all get to vote how we so desire. But my question is not so much how can I convince you to vote one way, but how can I, what is the conflict in your head that maybe we can talk through and help clarify?
Yeah, I don't know that I have a conflict regarding the design of the project, the 40B regulations and what we're sort of bound to. And I do understand what you've talked about, I mean, the need for housing. Jimmy and I grew up in town. We were in the same high school class, you know, but the town is now 50%, the population is 50% greater than it was when we were in high school.
Yeah.
And so is it the population of the United States and the population of the world.
Right.
There's just more people, right? So I certainly understand the need for housing, and we don't sort of freely allow people to do that, to create what is needed. And it's, you know, some people had asked, why can't it be in another area of town? Why can't the town plan better? And maybe through zoning, if we had made it easier for developments to occur, large-scale developments in other areas, maybe that would have occurred naturally, but the town isn't builders, the town aren't developers. We don't get to choose, you know, where a developer is going to come in with a 40B project. We're sort of just screwed, you know, with whoever comes in gets to do it. But it is putting an awful big burden on that neighborhood. You know, I think there's a lot of great benefits from all the Mills projects that you guys have done. I think a lot of that has enlivened that neighborhood and been very beneficial. You know, everything comes with some trade-offs that, and the neighbors are the ones who bear most of the brunt of that. But, you know, they do get to walk over to Jamie's and do that sort of thing if they choose. So I'm just conflicted in my own head, I don't think.
Yeah, okay.
I'm not sure. I just have to come to a conclusion. I don't know that there's anything you can answer for me.
But there's nothing about the way that everything is currently phrased that would be
No.
influential one way or the other.
No, I think the only thing that would be, you know, if it was quite a bit smaller and not quite so close to the neighbors, that would have been, you know, made it a lot easier. Everything else is sort of nip and tuck, and I agree, but I also understand that that's, you know, the best we could do for them, perhaps, and I think we made an effort to get there, and everyone wants more, and a lot of them want us to just say, screw it, we'll fight it, and we'll, you know, say no and take the fight to court if we need to, and I just don't know that that's the right, you know, we're also representing the town here, and I don't think that's the right thing to do for the town either.
Well, and you know, as we discussed with 39, with the closeness to 39 Prescott at the initial, right? Like that was the sort of the one that I was like, okay, that's big enough that I might be willing to fight a losing battle to really go after, right? And I think when they addressed that, it became much harder to find a place that I looked at and I said, I can't allow this, like this narrow specific thing. I think the closest was the proximity to Prescott Street on that, on the west side, right, of the building, like how close the building got to the street itself, and thus how
right
close
across
to
the street from his
right.
house, Mike's house.
But and that got closer to the line than some other things. But for me, the trick there was the problem there is that you still have the street there, and I think it would be very hard for the housing agency to say that you can't have the building across the street from another house. That was a very difficult one to try to push on. Whereas I felt like the way that the building was
Because
originally
they
laid
are,
out, it
in a
looked like
lot,
it was
in a
gonna
lot
be
of
a-
areas, out, you know, apartment buildings are built right on the sidewalk. And
Right.
so they don't see that as a, you know,
Exactly, a
as
deal
a
breaker.
reason, right.
And there would
Yeah.
be two other houses that would be basically just as close, even if that one part had been pushed back. So it felt like a harder, I mean, we did ask, and it was,
I do echo Ms. Craig Coman's comments from a couple meetings ago, where it would be really nice if there's just like one tree right there, right? Like just one tree would have really made a big difference.
that
but-
rendering looked really good.
Yeah.
Just saying, it looked really good.
That honestly would have made it a much easier call for me on that end. But
I just think if it was an easy process, they wouldn't have done a 40B. And,
Yeah.
you know, they could have kept all the setbacks and the height and all that, but I think it's difficult where it's overlay district and we're talking with 2 different zoning bylaws, and the fact of the matter is, it is a 40B, so I think that our hands are tied in some of the major decisions that we can't contest, right? So, but I think, I don't think nobody's gonna say anything that, or help me make any better decision, so.
And when I talk to friends who either work in this space or are journalists in this space, the thing that I hear from them over and over again is actually how hard funding is. That it is really, really hard to fund housing developments in general, but that affordable ones doubly so. That it is very difficult. And the state has tried to make some recent changes to make it a little bit easier to get some funding there, but it's tough, and especially with interest rates on the higher side than they had been, a decade ago. It means that a bank that is investing, or investors that are giving loans to this kind of project, need to compare it to where else they could spend their money and what else that they could make money off of doing. And so it's a challenging environment. And so I understand the abutters' feelings that this could be a lot smaller and still be profitable. I've had people tell me that they used to work in affordable housing and they don't do it anymore because it was not viable, and it was almost impossible to get anything funded.
Well, even fully market rate apartment complexes have had a huge decline in new construction for those, just because even those have been hard to finance over the past couple of years. So it is going to be a challenge. That's for them to deal with, and that seems like they're pretty good at that sort of thing. So they'll probably figure it out.
All right.
Melissa, you want to join in, or are you just listening?
I am absolutely listening and paying 100% attention. I don't know what I can add. I know, is it perfect? Nope. Is it something that we've put guardrails on and held up signs and said that's not going to fly? We need something here to get this to work. Yes. We've been, I think handed a bag of bees, and we found the honey inside of it from a certain perspective, because it's not an easy thing all the way around. But that said, I believe we've done our due diligence as a board. And I'm still kind of mind boggled at the fact that I'm here. So I was always just the alternate. So, I think that we just need to take the next step and move on. I don't have anything to add. I don't have anything I think that I can sway anybody with in one direction or the other. But, I very much agree with you, Chair, that we need housing. I would like my eldest child to be able to find a place to live at some point in time, and I have to make it happen. And I remember, or more to the point, I've seen photos of when this town was a lot smaller, because my great grandmother grew up here. So change is inevitable, and we're doing what we can to control it in the best possible way for the town and for the abutters and for ourselves as residents.
All right. I think we're about getting to the place. I guess from a practical perspective, we're used to reading out the a slightly modified version of the public notice and then referencing all the documents that we're citing. What does the process of the vote look like here?
It can be much more simplified, Mr. Chair. You could, a simple motion to approve the comprehensive permit to East Mill Housing LLC based on the decision that's been presented to you and is modified by your discussion this evening, and you can incorporate the waivers into that as well. Some boards like to vote separately on the waivers from the decision as itself. Some boards will even break down the waivers. You could vote on each one individually. You could vote on them as a topical group.
Is there value to voting separately on the waivers if there's not one that someone's gonna?
I don't see, short of there being one that someone says, I can approve all but, waiver number 12. If somebody feels strongly about that, then perhaps you can remove number 12 and vote on that one separately. But if there doesn't appear to be any real opposition to the waivers as we've discussed tonight, I think you could vote them as a slate.
So I'll ask the board's input there. How itemized do we want to get? Do we want to discuss them all as a single block? Do we want to vote on them as a single block? Do we want to vote them as 2 blocks? Or do we want to go through the waivers piece by piece?
Could I back up one more step first
Yeah.
and ask, do we feel like we understand well enough the changes that we've made tonight, even though we don't have it fully edited and clear?
Yeah, there was nothing that complicated. I don't think.
Okay.
I think it's clear.
Yeah.
I think it's clear. I think it just needs to be modified, and as long as the modifications are what we discussed as we were going through them,
Yeah.
I'm fine with I'm fine with just voting on all of them instead of.
Are you thinking we're gonna vote now? Is that you?
Yeah.
That's what we're driving at, Frank.
Versus having the final version?
Yes.
Well, that's why I was asking.
Right, so that's why Ms. Craig Coleman is asking. I mean, the alternative is that we can continue this to another meeting. My preference would be, unless there is a substantial change or a substantial uncertainty in terms of the content, that we vote now.
And I just want to add that I guess I had been thinking of this as a one and done vote. So I had been thinking of it as a very comprehensive package, and kind of, if I had objections to a single waiver or wanted something more different, would have spoken up prior to this point. So I don't have a problem voting in 2 packages if we need to, but in my mind, it is a package, and there's not anything that's going to make me, if we excise waiver 12, it doesn't change my mind or where I've arrived in my mind at this point in time, if that makes sense.
Yeah, I mean, I think that's exactly the point, right? So if there was one waiver that you're like, I don't want to grant the side setbacks, right? Because I think it needs to fit the zoning and stick there, and that I'm going to die on that hill. You could do that. But to your point, the effect of it would likely be to be voting down the whole package.
Right. And that's just not in any way, shape, or form how I've approached this process, I guess is what I'm saying.
Yeah, you view it holistically.
Right. I will say, however, Ms. Craig Coleman, if you want to die on the tree hill, I'm with you.
I think I have bled on the tree hill a fair amount, even though I have not died. And I mean, I do know a fair amount about how to protect trees during construction, and I think that we've gotten as much meat off of that bone as we possibly can. Slightly misleading rendering, notwithstanding. But I mean, yeah, with the retaining wall there and the grade changes, like, there's nothing would live. So it unfortunately just is what it is.
I do have one question, and not that I want to go this way, but if we were to do individual, and vote individually on each one, would we just need a majority vote?
Yes.
On each one? So it's, if one of us had an issue with 12 and the other 4 voted for it, it would not be, it would still be
Yes.
approved? Okay, so, again, I don't think there's anything in there that's gonna change my mind.
Okay.
Yeah, I mean, some of the items in the waivers were, if I were to, the ones that I don't like are ones that would kill the project.
Right.
And if that's how I feel, I may as well just vote no against the
Well-
whole thing. So,
Right.
so
If
like
I'm
Melissa
being-
said, I just,
If I'm being,
I see it as a comprehensive thing.
yeah, I mean, I think the
That's
reason
what it
to
says
vote,
right here.
I think the reason to vote on one thing at a time, if we wanted to do it, was as if we were prepared to vote this down based on a specific waiver, and we wanted to make really clear for a future court battle that this is the reason we're voting it down and not anything else, right? Then this serves that purpose, right? Because then it says, okay, when it goes to the court, we're not just saying the whole thing's ridiculous. We're saying this thing, and we're trying to be reasonable, but we reached an impasse here, and we can't accept this, right? That's what the value of doing that. But if we as a board do not expect to do that, then we don't have to go through the whole thing.
All of the questions about how many votes we need makes me think that at least one of you is gonna try to do like a conscious vote where you're like, I want to be the one to vote no, but knowing that it's still not gonna go anywhere. And I think we would all possibly be that vote for various things on this at some point.
I thought of that, but I don't think it's fair. I don't think it's fair to you guys. I think
Okay.
we all been here, and I think we should all vote how we feel, and, I'm not gonna just change my vote. I could have not come tonight and kicked out, and you guys would have had to go 3 for 4.
Thank you, by the way, for not doing that. I personally appreciate that.
No,
Yeah,
no
I kind of
answers.
agree with Jim. I mean, I wouldn't vote against it just to make a statement if it, and leave everyone else hanging, you
Yeah.
know.
Right.
Oh,
But at
you
the same
know,
time, I do want people
but-
to vote how they feel, right? Like, I don't want people to just be going along for the sake of going along, right? Like, we should be voting what we believe. And we have to own that, right? Because then if that vote has consequences, then we have to own those consequences. But we should be going with where we are and not necessarily trying to make a statement with it that is not actually something we want to do.
Okay.
All right. Well, Mr. Killalay, are you comfortable making the motion?
I'll start. Can you prompt me if I am?
Okay.
So I make a motion to approve the comprehensive permit application from East Mill Housing LLC for 0 Prescott Street, North Andover, Mass. Per the decision and waivers.
With edits that were discussed by the board this evening.
With edits that were discussed by the board this evening.
Do we have a second?
Do we want to reference the specific site plans, or is that all
It's all in
included
there.
in the comprehensive permit? Okay.
Yep, it's all listed.
I'll second.
All right. Ms. Rutherford,
I vote aye.
Mr. Testa,
Aye.
Mr. Killalay,
Yes.
Ms. Craig Coleman,
Aye.
and I am an aye. All right. It is voted. Again, I want to thank everybody for their patience and for their attention and their attention to detail. Ms. Murray, we'll follow up and make sure everything gets put in order. Mr. Smolak, my understanding is that we have 14 days to file the decision, and so hopefully you'll get notification in that time.
Mr. Chair and the board, I just want to express my thanks for your time and effort as volunteers. Going through this the first time is not easy. You could have fooled me. I think that the board really was thorough and very thoughtful, and in my 30-plus years of doing this type of work, I'm sort of mindful of the fact that I can't really think of a board that's really been as deliberative and thoughtful and concerned about all these factors that you usually find in a typical project of this nature. And I think that the town is really well served by this board and how it went about its deliberations and its review, and really appreciate that as a resident of the town as well. You've done a great job and appreciate it.
Thank you. All right, do we have a motion
Make a
to
motion
adjourn?
to close public comment, or no, to adjourn? Adjourn it entirely.
Do we have a second? Second. All in favor?
Aye.
Aye.
All right, we are adjourned. Thank you very much, everyone.